welcome to the Law and Policy panel. My name is Brigham Daniels. I am a professor of law at BYU Law School. Craig and Andrew, can you introduce yourselves briefly?
Sure. My name is Andrew Follett. I'm a student at Yale Law School, and I've been interested in the law of Utah Lake since I was an undergraduate at the University of Utah.
My name is Craig Galli. I'm a partner in the law firm Holland and Hart. Recently returned from 3 years abroad, so this project is very new to me, but having been an adjunct law professor and interested in all things nature in the Great Salt Lake and Utah Lake and the Wasatch Mountains, I'm delighted to chime in with my 2 cents.
It's such a pleasure to have the other two of you on this panel. We're going to address 3 questions. Craig, why don't you take the first one? And that is, what are the federal law implications that folks should be thinking about when they think about potential development of Utah Lake?
Thank you, Brigham. In terms of the specific details about project development plans, I really am not privy to any of them other than what I have read in the newspaper and in the request for proposal from October 2020 from the project proponent Utah Lake Restoration Project. And I would just like to quote a paragraph from their request for proposal for environmental permitting that kind of sets the foundation for my comments of what a dredge and fill project would look like from a federal regulatory perspective. Quote, the project is a comprehensive plan to turn the clock back 150 years on the ecosystem degradation of Utah Lake, the largest fresh lake in Utah. The project aims to restore, improve, and conserve the water quality and ecosystem of Utah Lake's 200 billion gallons of fresh water through a combination of dredging and ancillary environmental works, beneficial use of the dredge materials, upgrades to 6 wastewater treatment facilities, and the installation of 40 biofiltration systems around the lake. And in addition to that, there's going to be a proposed eventual construction of artificial islands. When I first heard about this project, I was reminded by Daniel Burnham's great statement. He was the city planner for Chicago and Washington, D.C. He said, make no little plans. They have no magic to stir men's blood, and probably themselves will never be realized. Now, this Utah Lake Restoration Project, if anything else, is a big plan that has already stirred up at least some interest. My task today in the short amount of time is to discuss several environmental regulatory requirements, what the permitting process would look like, the administrative review process, and the judicial review process. And this discussion is not all inconclusive, but will simply provide some highlights of things to look for in the future. There are 5 federal environmental statutory requirements, regulatory requirements that came to my mind when I read a little bit about the proposed project. The first, of course, is the Rivers and Harbors Act, Section 10, which requires a permit for construction of structures in, over, or under, excavating from, or depositing material into any other work and any other work affecting the course, location, condition, or capacity of navigable waters. Now, this dredging project and fill project, if it actually were to move forward, might be one of the largest ever attempted in the United States, given the magnitude. So this will definitely implicate Rivers and Harbors Act jurisdiction of the Army Corps of Engineers. In addition, the Clean Water Act, Section 404, requires a permit to discharge dredged or fill material into waters of the United States. And Clean Water Act Section 401 requires any applicant for a federal license or permit to conduct any activity that may result in a discharge of a pollution into waters of the United States to obtain a certification from the state that the discharge will comply with the applicable effluent limitations and water quality standards, not only for construction of the project, but during operation and life of the project. The Endangered Species Act, Section 7, requires that federal agencies in consultation with the U.S. Fish and Wildlife Service ensure that any action authorized, funded, or carried out by the agency is not likely to jeopardize the continued existence of endangered or threatened species or result in the destruction or adverse modification of critical habitat for such species. And then finally, the National Environmental Policy Act, or NEPA, requires all federal agencies to evaluate major federal actions and inform decision makers and the public of likely environmental consequences of proposed projects and evaluate alternatives. Now, there are two requirements that I'd like to zoom in on that often are implicated in controversial projects involving dredging or discharging in waters of the United States. The first is NEPA requires an evaluation of the project purpose and need impacts, and especially of alternatives. But the Clean Water Act 404(b)(1) guidelines go one step further and require that, quote, no discharge of dredged or fill materials shall be permitted if there is a practicable alternative to the proposed discharge, which would have less adverse impact on the aquatic ecosystem, so long as the alternative does not have any other significant adverse environmental consequences. Now, what typically happens in a project like this is the Army Corps of Engineers acts as lead agency or co-lead agency to prepare an environmental impact statement to support legally sufficient, what are called records of decision under NEPA, the National Environmental Policy Act, and the Clean Water Act and Rivers and Harbor Act, which again, in the ideal world, addresses all the requirements of NEPA, the Clean Water Act, and other federal statutes. And we see NEPA and the Clean Water Act having similar but slightly different, the Clean Water Act having a more robust alternatives analysis to find the best practicable alternative. The administrative process can take years, as well as the judicial review process, because under the Administrative Procedure Act, these records of decision issued by the Army Corps of Engineers and other federal agencies can be challenged in federal district court. Let me give you two examples of the complexity and timing of this type of administrative review process, and then the subsequent judicial review process. Two projects that are probably known to a lot of you. The first is the Southern Nevada Groundwater Development and Pipeline Project. This was the project to proposed project to pump groundwater from northern and central Nevada and take it to Las Vegas in a pipeline to fulfill water needs. The NEPA scoping process in that project commenced in 2005. Maybe some of you in the audience were not even born then. BLM issued its final environmental impact statement and records of decision in 2012 after 5 years of litigation that I was very intimately involved with, as well as the permitting process. The district court issued its decision in August 2017, upholding the project, but remanding for one additional analysis required under NEPA and the Clean Water Act to determine the feasibility of mitigation for future impacts to wetlands and aquatic areas under yet to be filed Section 404 Clean Water Act permits. Now, so the agency was required to really look into the crystal ball and try to assess the feasibility of mitigation, even though we didn't know what the scope of those 404 permits would be. That was pretty extraordinary. That entire process then, from 2005 to 2017, took 12 years. And at the end of 2017, the agency, the project proponent, decided to abandon the project for reasons unrelated to the NEPA and the environmental regulatory requirements, based on rather water rights issues. The second, of course, is the Legacy Parkway litigation that occurred right here in Utah. The NEPA scoping process commenced in 1996. The Federal Highway Administration, the Army Corps, issued their final EIS in 2000. After expedited litigation, the 10th Circuit U.S. Court of Appeals vacated and remanded the project approvals in 2002. A new final EIS was issued 3 years later. There was a settlement reached between all of the parties, which resulted in a redesign of the parkway and new mitigation. That occurred in 2005. Construction commenced in 2006. Construction was completed in 2008. Again, a 12-year process, and these 12 years were expedited because of either a settlement or abandonment of the project. I suspect if the Southern Nevada Water Authority project was still going on in remand, now that I've come back 3 years later, I probably would have been able to jump right back into it. So these are very complex regulatory permitting projects, as well as judicial review that can take many, many years. So with that, I'll end it there.
Thank you, Craig. And I do think that's probably the most complex part of what we're looking at. So I appreciate you taking the time to walk us through that. That was very helpful. All right, next one for you, Andrew. Talk to me about talk to us about the state law implications of a project like this.
Sure. For the past 4 years, beginning in 2018 with the Utah Lake Restoration Act and now seen in the Utah Lake Authority Bill, the primary momentum in the legislature has seemed to be towards transferring the bed of the lake in exchange for restoration projects. And the major hook that policymakers need to be aware of is the state's public trust obligations under Article 20, Section 1 of the Utah Constitution, which essentially creates a trust relationship obligating the state to maintain perpetual control of some resources, such as the bed of Utah Lake, forever and for all generations of Utahns, so that no single legislature could just, by a simple majority, alienate huge amounts of resources and impoverish the public's trust portfolio. This section of the Utah Constitution, as it was suggested in a 2019 Utah Supreme Court opinion, essentially constitutionalized a federal public trust doctrine, which is best communicated in a case known as Illinois Central. And so Illinois Central, as it's relevant to us through Article 20 of the Utah Constitution, tightly constrains and controls government's ability to manage special resources like the bed of Utah Lake. It might allow for the disposal of lake bed for pinpointed, very limited purposes, such as the erection of a dock or a pier, but it certainly forecloses anything that might, quote, abdicate the general control of the state over lands under navigable waters, end quote, for example, an entire lake. Similarly, even temporary leases or temporary grants of control over these special resources can be struck down, as the court said in its case Coleman. And so we take from all of this that the state, whether it be through legislative charter, the FFSL, or the Utah Lake Authority, attempting to permanently surrender significant portions of Utah Lake, should be aware of the state's trust obligations, as well as the state judiciary's ability to intervene and stop any of these oversized transfers. Similarly, because, as the Utah court stated, it's a matter of federal common law, the federal judiciary, which has previously stopped sovereign land transfer as small as 20 acres, would probably have a hook to step in. And so although private capital is certainly welcome in remediating the lake's woes, the lake bed itself, the public trust doctrine teaches us, is not a permissible matter of compensation.
Thank you, Andrew, and thank you, Craig. I think that what we're seeing is that there's a pretty steep hill to climb for a project proponent. But just shifting gears just for the last couple minutes, I want to just spend a little bit of time thinking about this Utah Lake Authority. and I realize that the idea of the Utah Lake Authority is a work in progress, and we may see changes still to the proposed legislation. The question I would like us to address is, taking a step back from the specifics of that, what are the major things that we would, or the design principles we would look towards in trying to come up with some sort of legislation if we were going to create something like a Utah Lake Authority? And I'll start out with that, and I'll be quite quick. So for me, I think that there are two major components that I would be interested in seeing, and I think would be wise. The first is to minimize the state's litigation risk under the public trust doctrine. One of the things I would like to see is some provision that if there was going to be in a lake authority, for example, that had the ability to alienate property, I would want to make sure that there were enough safeguards put into place that any attempt to do so would conform with the public trust doctrine. So what I would really hope to do is the delegation that I would provide or recommend that would be to be provided should be constrained by the public trust doctrine, and make sure that there are some protections for that, including perhaps additional judicial review. The second thing that I would point to, that I just think this is such a complicated issue. There are so many different parties that have interests in the lake, all the municipalities around the lake, the counties. I would really want to make sure that those parties had an opportunity to be heard, and that the concerns that different entities that had an interest in the lake, that there was some ability or for those folks to be heard. So I would be looking for very much robust public participation requirements before any decision is made. I would also really encourage, to the extent possible, to make these decisions as collaborative as possible, particularly if you're going to be making such a large change that seems to be permanent in nature. Just on the way out, Andrew or Craig, do you have any other thoughts of things that you might point to as maybe design principles if you're going to try to create such an agency or an organization?
Sure, I'll hop in. I think that before any projects begin, the state has an obligation to all of us as taxpayers to demand adequate and very robust financial assurances so that we can be positive that project managers can either follow through on their promises and that they have the necessary means, or on the other hand, that they can clean up their mistakes should they fail or otherwise become insolvent. In simplest terms, this means that the state should demand that they show the money up front. I think that this is necessary for sound, conservative resource management. And I think otherwise the authority bill risks being a disaster.
And Craig, any last thoughts?
Yes, teeing off of what you said about the benefits of having robust public participation and collaboration, I will say that holds true of the federal permitting process as well. The fact that it takes so many years to go through the NEPA and Clean Water Act, Rivers and Harbors Act evaluation process makes some project proponents feel like, oh, wow, we want to disengage. We want to share as little information as possible. We want to hunker down. But I would argue, both from the perspective of a former Department of Justice attorney defending Clean Water Act permit decisions issued by the Army Corps of Engineers, and then in private practice, both defending and challenging environmental impact statements and 404 permits, I would say that the more robust the collaborative process, the more transparency, the better documentation that exists, the better the administrative record is for those who are trying to defend it to be able to point to efforts to completely flesh out issues of concern and evaluate them in a robust fashion. If we had more time, we could talk about the 2 case studies that I mentioned and the failings of both projects. The small little issue that wasn't decided, it was because the evaluation was not quite as robust and open to public dialogue as it might have been. Hindsight is always 20/20, but clearly those projects where there's been a robust public hearing process and notice and comment process and responses to public comment, that provides the court and the interested public and the decision makers more ability to make reasoned decisions. And that is precisely the purpose of NEPA, as well as arguably the Clean Water Act. So with that, I think our time is over. And on behalf of the panel, we appreciate your time and attention.
Thank you.